All right, let's jump right in. Welcome to today's Explainer, where we're going to unpack a really fascinating real-world administrative law case. If you've ever lived in a neighborhood with a homeowners association, well, you already know that the balance between community rules and individual rights can get a little complicated. Today, we're using official hearing documents to demystify exactly where the legal boundaries of an HOA are drawn. We're looking at a very specific clash, the Sellers versus the Crossings at Willow Creek Property Owners Association. Here's our roadmap for today. We'll start with the homeowners versus the HOA, move into the first dispute about committee meetings, tackle the second dispute over withheld records, and wrap up with the final legal verdict. Let's get to it. So, Section 1, Homeowners versus the HOA. Let's set the stage. In one corner, we've got the petitioners, Homeowners John and Debborah Sellers, and in the other corner, the respondent, the Crossings at Willow Creek Property Owners Association, located in Prescott, Arizona. You know, this wasn't just your standard neighborly squabble over a property line. This conflict escalated all the way to the Arizona Office of Administrative Hearings. The Sellers actually filed two separate petitions against their HOA, and those were eventually consolidated into one major hearing. Moving right along to Section 2, Dispute 1, the open meeting debate regarding committee meetings. This first docket is all about the HOA's Architectural Review Committee, or the ARC. The Sellers' primary grievance? They claimed a, quote, failure to notice and conduct publicly ARC meetings. Basically, they were arguing that the HOA was straight up breaking state law and community documents by holding these committee meetings behind closed doors, without giving the neighborhood proper public notice. And this table really highlights the legal friction here. On one side, you've got Arizona state law, ARS 33-1804, which mandates that any regularly scheduled committee meetings absolutely must be open to all members. But look at the HOA's specific bylaws. Article 11, Section 3 says the ARC shall meet from time to time as necessary. Do you see the disconnect? The law dictates rules for regularly scheduled meetings, but the bylaws outline a committee that only meets as necessary. So, how did the HOA defend itself? Well, during the hearing, HOA representatives testified that these meetings are strictly on demand, meaning they only meet when residents actually submit architectural applications. Sometimes they don't meet for months, and sometimes they meet multiple times a month. Because there's literally no regular schedule, they argued they didn't need to post formal public notice. Plus, they testified they never actually locked anyone out, and the property owner submitting the application is always invited to attend. All right, Section 3, Dispute 2. The secret records debate. This is where things get pretty heated. The second docket escalated over a request for some highly sensitive documents. Just check out this quote directly from the homeowner's petition. They stated, the HOA, via its attorneys, have flatly refused to supply any records. They were specifically looking for invoices from the HOA's law firm and communications between those attorneys and third parties. The Sellers felt this refusal violated the rights to review community records, especially since they were concerned about an ongoing lawsuit the HOA had with the city of Prescott. And here is the HOA's primary legal shield, attorney-client privilege. The HOA invoked Arizona Statute 12-2234, which is a massive legal protection. It literally prevents a lawyer from being forced to share client communications or advice given to that client without the client's explicit consent. The HOA's stance was that the invoices and communications the Sellers wanted were fully protected under this exact statute. Now, while it's true Arizona law generally says HOA records should be available to members, there are strict exceptions. Under ARS 33-1805, an HOA is legally permitted to withhold records if they involve privileged attorney communications, pending litigation, closed board meeting minutes, or the personal and financial records of individual members. The HOA leaned heavily on these statutory exemptions to justify their refusal. So we've got the charges, secret meetings and withheld records. And we've got the defenses. Meetings are on demand, not scheduled, and records are protected by attorney-client privilege. The million-dollar question we're left with is, did the HOA actually break the rules? Let's find out in Section 4, the final legal verdict, analyzing the judge's ruling. Before we look at the verdict, we need to understand the rules of the game. In an administrative hearing like this, the burden of proof falls entirely on the party making the claim, which in this case is the Sellers. They had to prove their case by a preponderance of the evidence. In plain English, they had to provide enough evidence to persuade the judge that their claims were more likely true than not. So let's look at Administrative Law Judge M. Douglas's final conclusions. On the first dispute about the meetings, the judge sided with the HOA. Since credible testimony established the meetings weren't regularly scheduled, the statute requiring public notice simply did not apply. And for the second dispute regarding the records, the judge concluded the HOA's refusal was completely valid based on the statutory exceptions for attorney-client privilege. In both cases, the judge ruled the petitioners failed to meet that burden of proof. The ultimate result? Both petitions were officially dismissed. Case closed. The legal document explicitly states that the homeowners were not the prevailing party and that no action is required by crossings. The HOA's practices regarding their committee meetings and their document retention were completely vindicated by the administrative court. Now, a judge's ruling isn't actually the absolute final step. There's a path to legal finality here. The decision was issued on January 17th, and then it had to go through a mandatory agency review period. The department had until February 26th to accept, reject, or modify it. Because they took no action to change it, the decision was officially certified as final by Director Cliff J. Vananel on February 28, 2013, officially closing the book on this dispute. This case is really a masterclass in how state laws interact with community bylaws. We all want absolute transparency in our neighborhoods, right? But what we've seen today is that the law clearly carves out protections for HOAs, especially when it comes to informal committees and privileged legal advice. So it leaves us with a pretty fascinating question to ponder. Where do you draw the line between neighborly transparency and strict legal boundaries in your own community? Thanks for tuning into this explainer, and keep learning.